All right, finally. So apologies for the delay. It should be up and going now. All right, for this session, we're going to talk about powers of trustees. Just going to go through and talk about what things they can do. And if there's one takeaway from all of this, it's that, and it sort of goes back to really the fundamental nature and point of trust, which is to separate the good bits and the bad bits of owning property, that trustees have duties. They have to do things, and their primary duty is to look after the property for the benefit of the beneficiaries. And so all of the trustee powers essentially flow from them needing to fulfill those duties. That's really the key takeaway from this area. We're not giving trustees powers for the sake of letting them do things, for the sake of good governance or good citizenship. It is essentially Parliament and the courts as well, mapping out what trustees can do in order for them to fulfill their fiduciary duties, to look after the economic interests of the beneficiaries. Okay, and they come from three different areas. The first is from the instrument itself. That is, a settlor can clearly map out things that their trustees are allowed to do in regards to the property. And if we kind of think about that, again, it mirrors the way that contract law works. In contract law, you map out what the intention of the parties is in terms of their obligations here. The instrument, which again, in a will for testamentary trust or in a deed for inter vivos trust, the instrument is designed to clearly map out the settlor's intent. And if the settlor's intention is for the trustee to have the scope to do certain things in regards to the property, that's fine, provided that it doesn't go against some sort of policy, which again is managed by the courts, or things that have been enshrined into the Trust Act itself. In other words, things that Parliament has stepped in and said that all trusts have to follow these certain rules and standards. Or in some situations, the trust deed can't limit the trustee's ability to go and do certain things. Okay, so that these powers, they sort of fall and flow from a variety of areas, but you'll see whenever we go through them that they essentially have a corollary in a duty. They're given powers, but only to fulfill certain duties. Right. So start with the duty to account. And so that this idea that trustees, as part of their role, have to actually provide some sort of accounting. They have to, as part of the fulfilling their duty to beneficiaries in regards to their mere equity to provide good administration, trustees have to be able to demonstrate how and what the property is and how it's being managed. This function, though, if we think about it, isn't really a core aspect to most people going and being trustees. In other words, most people who are trustees are not accountants. Many are, and professional trustees and professional organisations will usually have a very strong accounting background. But it's not, strictly speaking, a requirement for being a trustee. The only requirement for being a trustee is the ability to hold legal title. Now, obviously, in situations where we as trustees are having to go and fulfill our duties, one of which is to do bookkeeping, we're going to need or have some sort of scope to get third parties in to help us out. And so that's what the Trust Act, and a lot of this lecture, by the way, is just going through particular parts of the Trust Act and explaining the why. it's reasonably readable, the Trust Act itself. It slightly predates the idea of using plain English language. This is a 1973 Act, and sort of mid-70s they shifted around. And so by the late 70s, acts in Queensland anyway are a bit easier to read. And also note that trust, because it's enshrining rules of equity as well, those things can sometimes be tricky to explain and map out without using some legal technical terms. But nonetheless, Section 54, subsection 1, gives trustees the power to appoint these particular types of agents. Now, I've included in that particular heading, the second part, this being able to be compensated for expenses properly and reasonably incurred. That comes from Section 72. That comes up again and again throughout this lecture. I've probably mentioned it about 5 or 6 times. So this idea that Section 72 gives a statutory mechanism for trustees to seek reimbursement from trust funds. It's a really important thing to note, because it gives them the power to go and take money away from the trust fund and to appoint it and to reimburse it themselves. Because in theory, the trustee spends their own money first, then seeks reimbursement. In practice, and certainly for those that have studied trust accounting with me earlier this year, in practice though, while that is one way of doing it, if it's clear that you have the power to actually use trust funds, you can write a trust check. In other words, a check drawn directly from the trust funds. Now this, what are we in, 2019? So yes, lawyers still have trust accounts. Yes, they still have checks. But for the vast majority of these sorts of situations, things are done through direct debit with minutes stored electronically. So just make note here, and this is a really useful, I think, starting point from the mechanical aspect of it. If the expenses are properly and reasonably occurred, in other words, the trustee has power under the statute to spend that money, they can do it directly from the trust accounts, again, usually through direct debit. If you do listen to Tom's recordings, he'll speak, I think, exclusively about checks. And when, for those that are doing trust accounting next year, probably going to have me as well, we'll be talking about the drawing from a special type of trust accounts, which is the trust accounts that solicitors must have to keep. And we talk about the general trust account, and we talk about the office account. The office account being the law firm's money. And often, it's easier to actually just use the law firm's money to go through and do things than it is, and then seek reimbursement in one go, just for administrative convenience. But this can vary between the two here. As a trustee, you can be appointed trustee in a variety of situations. And you guys, from this point forward, whether or not you want to actively act as trustees, I mean, that's going to be up to you. It's a voluntary position. But just make note, when you're going and incurring things, you can go incur the expense yourself, in other words, pay for it yourself, then seek reimbursement afterwards. If it falls in one of these, a specific category in the Act, you can seek payment from the trust fund directly as well. All right. And the reason why, of course, that we have these things, these accounting rules, and this came up in Pateman and Hain, where the Judge Finn, I think it was, did go through and map out this duty to provide accounts to demonstrate annually what is the trust property and how is it being invested. And that's a duty that the trustees have, and upon demand of the beneficiaries. In Hancock and Reinhardt, you may recall that John Hancock had actually gone. John was Gina's son, who was wanting her to be removed. One of the grounds they were seeking to do this was that she had failed to provide them with true and correct accounts, again in breach of her fiduciary duty. Okay, trustees have some powers, mapped out powers, in regards to real property. And so the Trust Act maps out quite a few sections in regards to this. Real property, because it's special. Obviously land is scarce, no one's making any more of it. And because real property is often very expensive and often has charges and securities and mortgages against it in many situations, the Parliament has intervened reasonably heavily in regards to how trustees can go and do things. But we know that trustees have certain duties in regards to trust property, and again, I'm thinking real property here. For example, actually take it into account, go and inspect it, go and see whether or not it's wasting, go and see whether or not it's earning some form of investment return, or if necessary, go and see if it needs to be sold or not. Those are duties. We talked about those last week, and that idea that you have 6 months for an inter vivos trust and 12 months for testamentary trust to go through and actually account for these things, either get the thing towards being sold or get it generating income. Okay. Also note that these duties, one of the fiduciary duties is to go and get the best price. So if real property has to be sold, they have a fiduciary duty to do this, and they can do it by a vote. In other words, a unanimous vote for a discretionary trust or a fixed trust, essentially a private trust, private intentional trust, or a majority vote for a charitable trust. And the part of this, again, this duty to make sure they get the best price, there's a duty to do this. So as part of that process, they have to go and actually see what the best price is. And so the Act gives them power to go through and expend money in order to get things valued. What is the best price? It's up to here. Now, that's actually important because you may or may not remember from equity when we talked about, or Tina would have talked about, this idea of auctions, going and putting a real property out for auction, in theory, provided it's been well advertised, provided it's not done on the Friday afternoon just before Christmas, and an appropriate amount of marketing has been done in regards to it. In theory, an auction will always get you the best price, or at least the market price. With the rules in sections 34 and 51, if the trustees intend to sell it directly, they have to go and get it valued. That's part of that process. And as such, they have the power to go and spend money to do this. Go and get the property valued before selling it directly. Right. Again, as part of fulfilling their fiduciary duty to maintain the property, trustees are given a corollary power to expend trust money to repair and maintain that property. So they get a no questions asked, uncapped power to reasonably, properly pay and be reimbursed for repairing and maintaining real property. That one kind of makes sense. But capital improvements, things that are of a capital nature, in other words, that are designed to enhance the value of real property, they are capped at $10,000. So you can only spend up to $10,000 without going and seeking approval from the court. The exception for that are the things in section 33, sub 1, sub F, which is things involving roads, streets, access way, service line, footpath, sewerage, water, electricity, drainage, other works that are, in the opinion of the trustee, likely to be beneficial to the property. Note that that list of improving things doesn't actually apply, strictly speaking, to the trust property itself. So you can go and spend money on these things, on an adjacent property or another property, or a property by which you have an easement right over, for example, provided that it is beneficial or likely to be beneficial to the real property that the trustee is holding. So you can spend money on someone else's property if it is beneficial, and you still have to be able to demonstrate that. It's your opinion. But again, like all opinions of a trustee, it has to be honestly and reasonably held. And so that power essentially is uncapped. So the trustee has the power to go through and spend this money as they see fit in order to enhance or benefit the trust property itself. Okay, some other powers that the trustee gets flows, again, from other things they need to do in regards to property. One of them is that in regards to property, the act of actually letting it out or leasing it is important. It's an important way to go about generating income, is to create essentially a lesser estate on the property itself. And that can come up in a variety of ways. One of them is simply to grant a lease. Hey, here is some real property. We would like to grant either a short or a long lease in regards to that. Just make note that trustees can run into some difficulties with long-term leases because they have a duty in order to look after the beneficial interests of the beneficiaries. The long-term leases can sometimes be problematic. The rates are set in place. The reason for that is that at the time that the lease is entered into, trustee is fulfilling their duty to try and get some sort of income. But in however many years' time, they have to take into account the fact that in 9 years' time, that lease might not be the best interest of the trustee. And those things are difficult to predict. The other thing that trustees have to account for is different classes of beneficiaries. I talked about that last week. This idea of the maintaining capital and income for life tenant as opposed to remainder men. Because in theory, they have competing interests. A life tenant wants to use as much stuff, particularly as much capital as they possibly can, draw down as much as they possibly can throughout the time they have the property or throughout the duration of their life tenancy. Whereas the remainder men want to have a lot of capital left over after the life tenancy ends. And so these things can be difficult when the trustee is making a decision to enter into leases if they're going to last for a long time. The trustee has the power to subdivide, but given that power, again, it has to be used for the benefit, the economic benefit of the beneficiary. And they can grant easements in such ways. You guys, again, this should be pretty familiar to you. Most of you would have done both Land A and Land B by this stage. The second part in there, and again, this is mapped out in Pape and in Hain. One of the great burdens of holding real property are all of the mandatory expenses that come with it. Rates, other forms of taxes, maintenance in terms of repairs, which was on the previous slide, and insurance. Now, Pateman and Hain said that, look, strictly speaking, there isn't a duty, a strong actual duty to insure, but the trustee will always remain personally liable if they don't insure the property or they fail for whatever reason. Can't exclude that. They're going to be personally liable for failing to insure the property. Now, it's not a strict duty, but the paying of insurance premiums as a result can be drawn directly from trust funds. All of these things, and again, I've mentioned Section 72 again here. All of these powers that the trustee have to do certain things entail the reimbursement power in Section 72. Now, we've talked about this a few times in shoots, and again, we'll talk about it some more today. This I guess, conflict between the way that directors work in regards to companies and trustees work in regard to trusts. The types of duties these two fiduciaries have are different. Company directors are supposed to take normal business risks as part of fulfilling their fiduciary duty, whereas trustees are to act for the benefit of the beneficiaries to maintain the property. They are not to take ordinary business risks as part of that duty. The two don't align. And so Parliament has actually jumped in on this one. And there is a rule, this is the default rule. If the instrument doesn't say otherwise, a trustee can only carry on a business for 2 years. Usually, this is if a business is ongoing at some stage and then has been moved into a particular trust. Again, this can be through the testamentary trust, for example, or when things, in theory, could be done inter vivos, when a person becomes incapacitated, for example. And the idea is that the court says you're going to need some time to wind this up or on-sell it as a going concern. And so that's the default. The instrument can override that, and unanimous consent of the beneficiaries. And so in Vacuum Oil in Wiltshire, it's a case, I think it was about during the war, it involved a petrol station. A petrol station where I believe the guy died, so he ended up in a trust. And so the trustees at this point were aware that this particular petrol station was the only petrol station in Broken Hill at the time. So they thought that might be useful or good as in terms of a business. And because it was the only petrol station at the time, that was beneficial for the community. And under the equivalent of the New South Wales Act at the time, they had gone and sought permission from the court to carry on running a business. But it was only for a finite length of time. And so they carried on after that time. And the issue, and this, as it went to the High Court, was that the supplier of fuel for that petrol station knew about all of these things and carried on supplying. And so they carried on supplying, and then it went broke. And the issue was whether or not the trustees were going to be held liable or not. And the answer is yes. Yes, the trustees are going to be held liable because they had acted outside the scope of that power. Breached the fiduciary duty, business failed, they were held liable. The fact that it was beneficial to the community, the local community, was quite irrelevant. So that idea that doing things that may be good on the surface of them doesn't matter. Trustees' duty is to maintain the economic benefits for the beneficiaries. And by carrying on this business, they failed to do that. Okay. There is statutory power to extend this without going to court if you can demonstrate the business is going to be sold as a going concern. So if by going concern, that means on selling the business and letting it continue to carry on in entirety. Just change the name of the owner. Selling things as a going concern. If you can demonstrate that you're doing that, you don't have to wind up the business and sell assets and so on. And of course, the court has power to grant extensions. do note that trustees often do have quite wide scope for carrying on business. Certainly the one you guys had in your first tute would have given wide scope to essentially override that section. Okay, one of the powers that trustees are given is a little bit of scope to negotiate and settle debt matters. So if the trust is owed money, or for whatever reason the trust has the right to sue, the trustee has statutory power essentially to try and get the best result for the beneficiaries. This power to go and negotiate, sometimes to negotiate for a lower amount that's payable now. The Act gives the power for the trustees to do that. And that kind of makes sense because at the end of the day, we care about the beneficiaries' economic interests. And we know, as law students and future lawyers, that most of the time we don't want to go to court. In most situations, we'd rather settle out of court for a much lower amount because we know that that's going to be the best economic outcome. It's not going to have to go through the hassle of paying lawyers. We're not going to have to take into account the risk of losing. And in the case of debtors that look a little bit, for want of a better word, flaky, that have a bit of money now, but you're not sure if they're going to have much money later, having a bit of scope to be able to accept that and release them from liability can sometimes be the best economic outcome. And so the trustees are given some power under the Trust Act really to fulfill that particular aim or that end. And also granting extensions. Trustees are not going to breach their duty if they grant an extension to somebody and give them extra time to pay. Borrowing money seems a little bit unintuitive, but trustees are or can have the power to borrow if the instrument says so. Because if we stop and think about it, by borrowing money, that's incurring debt for the beneficiary. And here, we're really thinking about, because there's no particular person we're borrowing against, it has to be borrowing against the thing. So it's really to do with mortgaging or issuing some charge against items of personal property. And so this can be done if it's mapped out in the instrument. And really here it's the gaining of and obtaining of mortgages against real property. Because in many situations, actually obtaining a mortgage and having money that can be beneficial, can have some benefits for the beneficiaries, particularly in situations where the trustee has and holds only legal title to property. So if we think about it, if you have real property and there's a point in time where it's not generating income, the money has to pay rates and to pay repairs and so on has to come from somewhere. And so that's an example of a situation where these things, you could go through and do that, but must make note, it's only can be done through the instrument. Okay, trustees have a power, or have the power, to invest money. I mean, it makes sense. They've got a duty to go and maintain the trust property and to advance the economic interests of the beneficiary. These are the fiduciary duties they have. Clearly, there has to have some corollary, some ability for them to go and invest money in order to do that. But there's powers to do that, and there's some limits to it as well. The key thing to note is this: investing with conservatism and restraint. So that ASC and AS nominees that involved Mr. Windsor, who, amongst a variety of other things, had gone to purchase some unit trusts, but it had only gone and got the information from the vendor, hadn't gone and done due diligence in regards to those investments, was held liable as a result. A prudent person of business would go and make investigations. They would go and get multiple sources of information in regards to particular investments. They would and can pay professionals and be reimbursed out of trust funds, under Section 54, in order to examine the quality of investments. And it's important to note that the types of investments that trustees must take are low risk ones. So the corollary with low risk is low return. And so in this Nestle and National Westminster Bank case, there it was a testamentary trust from 1922, and the trustees invested in, I think, the equivalent of government bonds the entire way through. And so what was between 20 and 30,000 pounds in the 1920s, by the 1980s was like 250,000 pounds. But the beneficiary, when they found out about this, was extremely agitated. Why? Well, if they had just gone and put money in the bank, just an ordinary bank account, they would have earned much more money. They reckon her estimate was something like $1.5 million. Just going and getting the equivalent of, I think, called gilt-edged bonds, securities with the British government, has a very, very low rate. That said, that very low rate is still ahead of inflation. So she wasn't arguing that £22,000 back in 1922, adjusted for inflation, would have been more than the amount she got, which is about £250,000. She wasn't arguing that. She was arguing that just ordinary investments at any stage would have outpaced this. And she lost. And there the court said that, look, yes, trustees do have to go through and annually review investments. Right? They do have to go through and check these things. But 1922 through to 1986, some quite important things that happened to the British Empire in that stage. I mean, firstly, it ceased to exist. And so that idea of having government bonds throughout that period was not inconsistent with the trustees' fiduciary duty to look after the economic interests of the beneficiaries. Okay, but here there is that duty which is enshrined in Section 22 sub 3. And as we saw before, Section 54 sub 1 gives them the power to go and get professional help. You guys are going to be armed with knowledge of trust law, which is really good. But for those that aren't studying business, which I suspect is a good chunk of you, you're not going to have the accounting background to go through and analyze particular investments and look at their risk, look at their return, and to be able to make essentially decisions with appropriate professional level of skill and care in regards to those investments. Pay other people to do that and get reimbursed, or just pay directly from the trust funds under Section 72. Not by coincidence that I keep mentioning Section 72, because when you're going through and doing your exam, that's the mechanism that you probably want to go through and mention. Hiring of accountants, auditors and agents under Section 54, and then Section 72 to get reimbursement, or if it's under 54, to be paid directly. The trust funds to pay the agent directly. Okay, so what sort of investments are good? Well, Tom actually takes, who teaches this, has gone through and taken the old section 21. So this is not the current section. This is the old section. He said that it was changed 5 years ago. I went back, it was changed in 2001. So a little bit more than 5 years ago. But it used to be section 21. In fact, I think he even allowed you to go through and print this out and staple it to the back of your Trust Act, which if you want to do that, I don't really care. Go for it. But with these lists here, they've actually gone through and carefully mapped out things that count as low-risk investments, things that if a trustee goes and invests in, will satisfy the duty. They won't be held liable as a result. Okay, so this is the old section 21. And there's a lot. So where we go? Parliamentary stocks, public funds, government securities of the UK, of the Commonwealth, State or Territory of the Commonwealth, or the Dominion of New Zealand. Okay, so there we go. That's pretty close. I love the Dominion of New Zealand. You can do mortgages. You can purchase land in fee simple, debentures of security, of funds of property of the Brisbane City Council. Oh wow! Or of any other local government in the state. There you go. Buy bonds from the local council. Interest-bearing deposits in any financial institution. Bills of exchange by any financial institution, and there they're meaning Australian financial institutions. Any deal in the short-term money market approved by the Reserve Bank as an authorised dealer. In other words, people that have a vested interest to do this properly. Any security in respect of its amount of security and payment of interest thereon is guaranteed. So any investment which is guaranteed by the UK or Australia or any state of Australia or New Zealand. New Zealand, really? Okay. And again, a variety of other things here. They've gone through and mapped these things out. These are all low-risk investments, and the current version of Section 21 is much, much, much simpler. It's about 1/20th of that, in that they are given wide scope. So if the deed doesn't say so, trustees can invest. They're given much, much wider scope. They're not mapping out in the statute. They're leaving it up to the general law. Trustees still have this duty to act with restraint and conservatism, ASC and AS nominees, but the Act itself, from, I said, I think it was 2000 or 2001 onwards, doesn't map out the low-risk investments. However, some weight would be placed on that list. And so, and again, and Tom talks about this in depth, that idea that if you were going to cross your T's and dot your I's as a trustee, you would be wise to go through and look at that list and follow, and sort of in substance, if not in form, the theme of those investments. Low risk, low return investments. Okay, now trustees have a certain level standard of care, and that standard is higher for professional trustees. When we're looking, I think it came up in the class test, the Themis and Kane Hire case, that idea that professional trustees are held at a higher standard. So if you are in the business of being a trustee, you are held at a high standard in terms of the way these investments work. But make note here, and again, the court referred to this in ASC and AS nominees, that we don't want risky investments, even if they're going to have high return. because we need to maintain the capital. As such, we don't want assets that are going to fluctuate a lot. In theory, a beneficiary who is sui juris, not under legal disability, can demand their capital and all outstanding income that hasn't yet been allocated to them and end their share of the trust. Or all the beneficiaries could choose to collectively end the trust itself. They have that right if they're all sui juris. Saunders and Vortier, Manfred and Mandrell, and Whakatane paper mills. So just make note that that can happen at any time, notwithstanding all of these vesting clauses in the deed. So that this level of care, this standard that a professional trustee and ordinary trustees, though, are still held, it's still a very high duty, high fiduciary duty. They're still held to a standard where they have to be exercise restraint and caution in their investments and be prudent. Do what a reasonably prudent business person would do. That's the standard of care appropriate for investing trust property. The overarching duty, corollary duty, to this power to invest is this duty to maintain the trust property for the economic benefit of beneficiaries, both life tenants in terms of income, reasonable amounts of income, and capital for remainder men. So one of the mechanisms that you can earn income by risking capital is through the lending of money. So that trustees are given power to do this. Again, they have to do it and exercise that power with restraint and prudence. If they do that, and they act reasonably and honestly in regards to doing it, and the money disappears, the trustees won't be held liable. The trustees do have an excuse under Section 76. So they've got the power to lend under Section 30. Section 30 has a lot of powers to go through, but one of them is to lend money. I should probably put the subsection in there as well. But if the money disappears, if they have acted with restraint, if they've acted with prudence, if they've acted honestly and reasonably, then they will be excused and will not have to bear the cost of that loss. There you go, Section 30, so Section 30 sub 1. All right, and Reece Stewart, the trustee in that case, I think did 4 loans, and essentially breached in a variety of ways. Didn't go map things out in terms, or didn't seek financial advice in terms of doing it, didn't map out who and where the debtors were, didn't go and just didn't take all of the proper precautions that a person of business would do in regards to doing each of these loans. Didn't check the credit rating of the person they were lending to. Just lent money out without any real care and was held liable in that case. There's the 2/3 rule, by the way, where it's got the amount of loans no more than 2/3 the value of the property. All right, so that's yeah, because when you're when you're lending money, because you can act essentially as mortgagee. Somebody wants to buy a property, because this can happen particularly with close and family trusts. So if there is a trust, you're a trustee. One of the beneficiaries, for example, wants to borrow money to purchase real property themselves. Going and lending in that, it's a pretty common thing actually in terms of family arrangements. But you can't lend more than 2/3. The Act forbids it. And so that property has to be valued. The amount that you lend from trust property cannot be more than 2/3 that's going towards the purchase of real property. Okay. This may have come up already in this subject, but certainly has come up for those that have studied tax, either this year or may do next year, when we're looking at particularly beneficiaries who are minors. Minor is not minor isn't able to go and demand the trust to be ended. You have to be at the age of majority to invoke the rule in Saunders and Bourtier. But the instrument can allow what's called the maintenance or advancement or benefit of that particular person. Again, I'm thinking primarily here, thinking of minors. So before property vests or is able to be either for a particular age or particular time in the instrument, or if the person is under the age of majority, the trustees nonetheless can have the power to dispense income for their benefit. It uses these three terms, all right? Maintenance, benefit, and advancement. Maintenance is to help them live. So if you have a 17-year-old and they're sleeping rough and you're the trustee of their trust, you have statutory power to pay money out of the trust towards them in income. So income out of the trust ahead of the date that the deed or the instrument might actually allow that money to be paid. So if a person is destitute, they need money, you can pay money to them before the deed says so. Okay? That's maintenance. Advancement is not when they're destitute, but it's for doing things like bettering their education. You kind of think about it. Maintenance, keeping them up where they normally would be. Advancement, putting them ahead. So putting money towards their schooling, for example. And benefit, again, this was talked about in Pilkington. It's a Pilkington case. And Pilkington involved a 5-year-old. 5-year-old where there was some property, and the IRC is the British, the revenue equivalent of the ATO in the UK. And there was a 5-year-old, and a sub-trust was created. So I don't know if I talked about sub-trust when we talked about Ken and Spry. Sub-trust is where you guys are probably aware from Tina's subject that when you have a beneficial interest, that can be assigned. Right? You can assign that beneficial interest to someone. So if I have a trust, separated legal and equitable title, either it's a fixed trust, it's a proprietary interest, a discretionary trust, it's just a mere equity. Nonetheless, these rights can be assigned in under the statute, sections, I think it's 199 and 200 of the PLA. You can assign those things. So because you can assign them to somebody, you can assign them to somebody to hold the thing in trust. So if we think about that, we're assigning this to another trustee and then have beneficiaries, which could still be the same beneficiary, which is what they did here. And so the difficulty was trying to determine whether or not, in this case, the 5-year-old, the trustees who'd gone and moved these things, clearly the 5-year-old didn't know anything about trust law, moving these things into a subtrust, whether that was going to be subject to tax under that particular regime in the UK in the 1960s. Because it turned out if it fell under the statutory power, wouldn't be subject to tax in that situation. So that the trustees were trying to argue that this was a benefit to the 5-year-old. Moving it into the subtrust was a benefit, therefore exempt from tax. And the Revenue Commissioner's argument is that it's not a benefit. Benefit has narrow scope. Benefit has narrow scope in terms of how that should be applied. But the House of Lords disagreed. They disagreed with the Commissioner, and they said, no, we're going to give benefit a wide scope. It is advancing the economic interest of the beneficiary. So if we think about that, maintenance is about bringing them up to a certain standard of living. Advancement is about getting them ahead in life, again, usually personally and usually in the form of education. Benefit is about advancing their economic interests. So that this idea of benefiting them in some way actually was given wide scope in Pilkington. So just make note that for income, the trustees have the power to do all three to any amount. So income in any given year can be applied to beneficiaries under any of those three things. But dispensing capital is a little bit trickier because that's capped. It's capped under the Act itself, and so it's capped at either I think the higher either $2,000 or half the amount of the capital can be applied, and that's if situation where there are life tenants, they have to agree to this. So if we think about it, if you have a life tenant and then there are a remainder, and the life tenant wants to consume as much capital as they possibly can through their life, just again, we're thinking in terms of self-interest here. Whereas the remaindermen want the capital to be preserved. The life tenant's getting the income throughout the period, this period here. Remaindermen want capital to be preserved. And so that if the capital is paid out to the remaindermen, that comes to the detriment of the life tenant. And so here, the life tenants need to actually agree to this. If you're paying out capital as part of maintenance benefit or advancement of the remaindermen beneficiaries, life tenant has to agree with it. If there's no life tenant, if you've just got one category, then that's fine. Okay, I'll do going to end this particular part to do with powers. All right, and I'm going to turn the thing off. We're going to take a 5-minute break, and I'll come back and carry on with the next recording. So, see you in 5 minutes.